Ms. Barbirou.
Always forget that. Chairman Smith, thank you for committing your time today to address this issue of international parental child abduction, which I will continue to refer to as IPCA for brevity, and the implementation of the Goldman Act. I would also like to extend my gratitude to Ms. Christensen, who testified earlier today. She also mentioned a case she wouldn't name by name, but that a lot of activity had been occurring a day after one parent had called and said activity was happening. That was my case, so I'd like to extend gratitude to her for knowing what was happening and explaining that. And also to my fellow parents who sit with me today. I have held back so much emotion on my own, and for your own stories and your own children, you've touched my heart in so many ways, even knowing that I can clearly identify with everything you've been going through. So thank you for your testimony. And I offer that mine won't differ very much because all of our stories have so many common elements. So with that, as many of you know, the enactment of this legislation, the Goldman Act, is of vital importance to the thousands of children who become victims of IPCA in our country each year. For many parents seeking the return of their illegally kidnapped children abroad, the Goldman Act is a source of hope in the otherwise dim realities that our lives become after our children are snatched from our lives and theirs, exposed to the horrors of a life on the run, often aided by the governments of the foreign lands to which they are kidnapped. It is a source of hope that finally the right tools will be utilized to secure justice for our innocent children, ensuring the full force of the American government to secure their rights of protection as citizens to return home where they belong. That is the power, purpose, and hope embodied in the Goldman Act that has brought us here today. I am honored to have been invited to testify today after having sat before this very committee for the same purpose just 1 year ago. I'm also terribly saddened, personally, that I return and that my son Islam remains illegally detained in Tunisia. I'm also saddened for the thousands of children who remain abducted or detained as hostages in foreign lands around the globe. Exactly 4 years, 8 months, and 3 days ago, my children, Islam and Zainab Shebi, were illegally abducted to Tunisia by their father, a Tunisian native. At the time of their kidnapping, in 2011, I had full custody of both children and retained a judicial order preventing either of us from traveling outside of the United States with either child. In January of 2012, I boarded a plane to Tunisia to be close to my children while I pursued the application of my U.S. divorce and custody documents in order to bring them home. At the time, I was promised by my then Tunisian counsel that I would be in Tunis for a total of 3 weeks and could return with both children to the United States in that time. It was 10 months before I could obtain a first ruling through the Tunisian judiciary upholding my rights of custody of Islam and Zainab here in the United States. A few months later, in May of 2013, a Tunisian appellate court ruled for enforcement of Islam and Zainab's return to me in the United States. By August of that year, I was assured of pending enforcement and a return home with both children. In the face of what had, by this time, accumulated into extensive interventions by the Department of State, the Department of Justice, and multiple members of Congress, I chose to believe. Based on this belief, I decided to honor my daughter Zainab's wishes not to return to her father following a weekend visit and to rely on the legal process for enforcement for our reunification with Islam. I made that decision in September of 2013, and Islam has remained isolated from his sister and I ever since. Due to intentional interference by the Tunisian government to prevent enforcement of its own court's judicial order, Islam remains illegally detained as we continue to seek enforcement of that 2013 appellate court judgment upheld by the Supreme Court of Tunisia in 2014 today. Due to illegal extrajudicial interference, Zainab and I last saw and hugged Islam exactly 2 years and 15 days ago. She and I returned to the United States without Islam in August of 2014. Within the past 2 years, we received a second Tunisian primary judgment granting custody of Islam and Zainab to me in the United States, and a second appellate court ruling for enforcement of Islam's return home to our family in the United States. These are all Tunisian judgments. There are 5 now. In March of this year, the Tunisian Ministry of Justice informed the U.S. consulate and ambassadorial staff that this judgment would be issued and enforced, leading to Islam's return home to us in the United States by the end of May. Clearly, that time frame has passed. The entirety of these 4 years, 8 months, and 3 days since Islam and Zainab were kidnapped from our home, the State Department, the FBI, and numerous esteemed members of Congress have mounted incredible diplomatic and political efforts in support of our family with the Tunisian government for its adherence to a rule of law and compliance with its newly enacted constitution for enforcement of its court's judicial rulings and Islam's return home. My family is ever grateful for these necessary and powerful steps. Yet while we applaud these great efforts, we continue to accrue judicial order after judicial order. The Tunisian government continues to provide baseless assurances, and Islam remains illegally detained in Tunisia. I wish to step away from our family circumstances for a moment, return to the Goldman Act, and address you as an advocate for our innocent children, the true victims of this crime. According to the FBI, more than 6 children are reported as abducted by a parent in this country every day. Previous State Department statistics indicate that more than half of these children are kidnapped to foreign lands. In 2014, Congress unanimously voted and the President signed into law this powerful legislation that protects the rights of our abducted American children by ensuring that the strongest penalties will be rendered in the face of their prevented return to their homes here in the United States. Clearly, the U.S. government fully believed that the powers embodied by the Goldman Act were varied, necessary, and sufficient enough to secure the immediate return of the thousands of American children victimized by IPCA each year. Yet to this day, the Goldman Act has only been enforced to the least extent possible, and mostly in demand and review of annual compliance reports. In turning to the 2015 compliance report, I would like to applaud the great strides that have been taken to present a clearer and more honest picture of what is occurring with our abducted children abroad. In it, we have a stronger glimpse not only of what actions have been taken in each country where American children have been kidnapped, but also of the recommended steps toward improved resolution of abduction cases in the future. Sadly, not only was this report delivered late, but it also leaves the same alarming concerns regarding the enactment of this law that I addressed before this committee just 1 year ago. After reviewing the 2015 report, I have no clearer understanding of how many children have been kidnapped internationally by a parent from the United States and whether there has been an increase, decrease, or no change in the incidence of this crime. Simply providing an accounting of cases without identifying a total number of children affected does not bring us any closer to an understanding of the breadth of this crime on the American public. By my count, it takes an average of 5 years to secure the return of a child who has been abducted by a parent internationally, if a return ever occurs. Previous State Department statistics indicate that only 18% of IPCA cases result in a return. Forgive me. Considering that the average age of abduction is between 6 months to 6 years, we must understand the devastating reality that for those lucky enough to return home, they will have spent half of their lives as captives on the run. As Ms. Abby's testimony exemplified, having every available statistic about the number of children impacted by this vicious crime is imperative to every prevention and return effort embodied in this act. Second, not once did any of the descriptions of actions taken with any of the cited countries or the recommendations for future action incorporate any of the prescribed options 3 through 8 as required to be taken with respect to non-compliant countries per Section 202D of the Goldman Act. Hereforward, I'm going to refer to these as the 202D actions for brevity. In fact, I have not witnessed one instance where any agency within our government has utilized the authorities of actions granted through the Goldman Act to implement any of the 202D actions to be taken with respect to non-compliant countries. Respectfully, our children's lives do not rest on the actions of one governmental department, but on the collective action and escalating action of all government agencies wielding both their combined and independent powers. There has to come a point where every representative of the U.S. government becomes accountable for the implementation of 202D actions to secure the immediate return of abducted American children. As Dr. Brand has already stated, Sean Goldman himself was not reunited with his father on U.S. soil based on the actions of any one agency within our government. It took coordinated interventions across multiple agencies and congressional action to prevent a financial exchange with Brazil to secure his return home. It is my understanding that the lessons learned from the Goldman case were embodied in this act with the implicit intention of securing immediate returns for other abducted children abroad, not as an opportunity to re-engage in or intensify long-term diplomatic efforts. Given the Goldman example and the authorities granted under this law, I and thousands of other seeking parents rejoiced at the hope that enforcement of the Goldman Act would result in the immediate return of our illegally detained and abducted children. Sadly, today, you can stare, but I stare at times. We had a photo of my son here when he was 5. Thank you so much. Yes, so if you would like. When I stare at my 5-year-old son, Islam, and I wonder how I could look him in the eye when last we embraced, which was 2 years and 15 days ago, and explain that the government of the United States will enact a law granting authority to publicly condemn Tunisia for failing to uphold its new constitution and rule of law, to delay or cancel any of the 2 official visits that Tunisian leadership has enjoyed at the White House since your abduction, or to withdraw, limit, or suspend any of the billions of security and development assistance paid for in U.S. tax dollars to the Tunisian government, but that no one will act upon it. I wonder if any of us could tell our children with a straight face that we are fully aware of the psychological, emotional, and maybe even physical abuse that they are likely to incur as a result of being parentally abducted, but that politics and diplomacy take precedence. I wonder how Stan Hunkovich, father of Gabriel and Anastasia, who were abducted to Trinidad and Tobago by their mother in 2010, could look his children in the eye when last they embraced 4 years, 7 months, and 16 days ago, and explain that the United States could take strong, immediate action that could secure their return home, but simply won't. Chairman Smith, esteemed members of the committee and guests, what I need, what Islam needs, what Gabriel and Anastasia need, what all of our children kidnapped abroad need is every representative of our government to take every opportunity to, as it arises, to put our children first. We need every 202D action authorized by the Goldman Act, most specifically actions 3 through 8, to be enforced at every opportunity, whether within a committee of Congress, through the federal budget with respect to foreign aid distributions to countries cited as persistently failing to return abducted children home, through a policy of consistent issuance of extradition warrants in all IPCA cases and persistent pursuit of their enforcement, or by the refusal of official state visits and the suspension or withholding of development, security, or any other form of foreign assistance. The opportunities to secure our children's immediate return to their families in the United States are limitless. We and our abducted children care not from where within our government action is initiated. We care only about the result in our children's return home. What I need from my government to secure Islam's return home is the immediate and uninhibited enforcement of 202D actions 3 through 7 with respect to Tunisia, specifically a public condemnation and the suspension of all foreign aid until Islam is returned to our family in the United States. I end my testimony with a reiteration of my statements before this committee 1 year ago. To be clear, the Goldman Act, as it is written, is a fair and powerful law that includes strong remedies which, if applied, will result in the return of our illegally detained, abducted children abroad. It is my firm belief that with the application of any of 202D actions 4 through 7, Islam Shebi and Gabriel and Anastasia Hunkovich will be returned to their homes in the U.S. with immediacy. Diplomacy and politics have a place and purpose, but when a country persistently fails to return illegally abducted American children home, swift and immediate action must be taken by all. As Secretary Kerry proclaimed, there can be no safe haven for abductors, and all of the tools available must be used to help resolve cases of IPCA. Thank you for your time and consideration and for the honor of testifying before you today.
Ms. Barbirou, thank you very much for your testimony. Like the others that preceded you, it is moving. Welcome back, but I wish you weren't here, frankly, except perhaps talking about a success, which we've had in very, very few instances. So thank you again for your very candid and strong recommendations as well.
Thank you for the opportunity to respond again. I did just want to note, you mentioned there are people who care in these other governments and these other nations. It is not that it is full of people who are uncaring. And in fact, in this room is a member of the Tunisian embassy who is a very caring and committed individual to the law and the rule of law, whom I believe would like to see our case resolved. So to him and to other members of the Tunisian government who are attempting to act in good faith, I appreciate that. But that does not dispel the fact that the government itself has ultimate authority over the enforcement of the law in all of these countries. And so the recommendations of the Goldman Act or the actions within the Goldman Act are not personal, and they are absolutely necessary, as you stated, for the actual enforcement of the return of our children, which is the whole goal and purpose. And so I stand by that, but also thank all of those who do care and who are acting in their best efforts to ensure that there is resolution to our case. In terms of what Mr. Cook just said, it's interesting, we had similar thoughts, and so in my recommendations, in my written testimony, I provided a copy of drafted legislation that I wrote that offers a means of providing punitive damages to parents that are paid for by the countries that are found to have a pattern of noncompliance in persistently failing to return American children. Because there is that second definition of what noncompliance means. And when a country is persistently failing, clearly, even if verbally they are saying we are going to try and we are doing our best, then by action they are actually outrightly refusing. And so if our children are illegally abducted in those lands, then they are taking on the onus and responsibility of the parent who has illegally kidnapped them there. And when parents are devastated financially in this country, doing anything and everything that they can, wielding legal fees and translation fees and sometimes going into bankruptcy, doing travel exchanges, all of those things at our own cost, that's not fair. And I think at some point, I am hopeful that we see additional legislation that provides an opportunity for a pot to be made that benefits the parents in a way that we are not so financially devastated by this crime. I also just want to ask that, again, as I stated last year and stated also in my testimony, that one of the recommendations I have is that the Act contain an explicit requirement of accountability for the total existing cases of IPCA by country, including newly reported cases and the total number of children involved in each case represented in future compliance reports under the Act. I know that that may seem like a minimal thing. This report, as far as I could see, says there is more than 600 children who were abducted abroad. That is not a solid number. And in this country where we have no accountability to the total number of children who are impacted by this crime, it is vitally important that we have at least a basis of understanding of how many children we're talking about here. Because when the net widens, then the opportunities for others to get involved for prevention and return widens as well. I have other recommendations I hope that you'll review, and I thank you so much